Recently, our firm had a chance to work on an interesting personal injury auto accident case. And what made it unique was the fact that there was a defense raised by the insurance company that the driver of the at-fault vehicle had suffered from an emergency medical condition. So to back up and look at what happens in a normal one of these auto accidents, we usually have an at-fault driver and somebody who was not at fault or shared less fault than the at-fault driver. Florida allows you to split up the pie. It's a pure comparative fault state, meaning if you're 1%, you can recover for the additional 90%. If you were 50% at fault, you can recover for the other 50% at fault in terms of what your damages are. But what happens in a case where the at-fault driver or the insurance company defending the at-fault driver raises the defense that that person had no control of his actions, so he should not be held liable for the accident? Well, that is what can often pop up, especially if there's a medical emergency like a blackout. You see seizures and things like that, very serious medical conditions that can cause somebody to lose control of their vehicle or lose control of really all of their bodily functions and make it hard to control a vehicle or drive or operate a vehicle such as a normal person would do. The normal standard for people on the road that they have and they owe to all of us around them is to drive as a reasonable, prudent person would under same or similar circumstances. So that means following the rules of the roads, not hitting your vehicle into other vehicles. Some of them are very simple, some are a little bit more directly related to the laws that might have been violated. But at the end of the day, it all has to do with owing that standard of care to the drivers around you. When there's a medical emergency such as this, the Florida law carves out a little bit of a defense for these people, saying that if they had no idea and no way to expect that this medical condition was going to come up when it does, then maybe they're not liable for the accident. A good lawyer or law firm can fight back against that defense and make sure that that person that suffered this emergency had no history of treatment for this. We look at things, had they been seeing the doctors for the last year, 5 years, 10 years for this same issue? Did they know that there was a chance it could happen while they were driving? Were they prescribed medication that they were no longer taking, therefore increasing the likelihood of such a medical event occurring? All those are very important to get to the bottom to in an accident like this. And it's very important to have your law firm or lawyers to file a lawsuit and pursue all these facts in discovery. We can dig up medical records, we can find out all of that, and make sure that the plaintiff or the injured party who was not at fault in the accident is able to recover a settlement that's they deserve based on the injuries that they suffered.